Good evening, ladies and gentlemen. You're all very welcome to the Four Courts, this historic centre for the administration of justice in Ireland, and a very special warm welcome to Professor Townshend and to Mrs. Catherine Townshend. We gather for a lecture to be delivered by Professor Charles Townshend, and he's going to speak on soldiers and law in the Irish Revolution. This public lecture is part of a series of lectures which is organised by the Court Centenary Commemoration Committee, and the committee aims to commemorate centenary events which relate to the courts and to lawyers. The committee was established in 2013 when Ireland commenced its decade of centenary celebrations. The committee's members come from the Judiciary, the Court Service, the Department of Justice, the Office of Public Works, the Bar Council, the Law Society of Ireland and Trinity College Dublin, and we're planning lectures and events at the Four Courts over the decade of centenaries. The committee is organising this series of lectures and is doing so in an inclusive way, reflecting the diversity of Ireland's history. We hope that our endeavours will be of interest to those working in the law and to all interested in Irish history. Apart from the lectures, we've organised events in other areas. For example, we're very keen to engage with the young people, and so we launched a schools media art and drama competition, which ties in with the decade of centenaries and Irish history. And the winners of the competition came from St. Paul's Secondary School, Greenhills, Walkinstown, and St. Joseph's Secondary School in Drogheda, County Louth. Last June, we held a very successful guided walk around the legal quarter, commencing in the Four Courts, which took in some of the places relevant to events which we are commemorating. Over 200 people joined our walk. It was a beautiful, sunny summer day, and many more people applied than we could accommodate that day. And there will be further events in the months and years ahead of which the Court Service will keep you informed. Our island has a rich history which spans the millennia, but we live in a relatively new state. The events of 100 years ago had a decisive influence on the direction of this island and its people. We think back to the labour strikes, 1913, the World War, 1914-18, the 1916 Rising, the War of Independence, the Civil War, nation building and building peace. Ladies and gentlemen, it gives me great pleasure to introduce our speaker this evening, Professor Charles Townshend. Charles Townshend is a professor of international history at the University of Keele, a public research university. He was educated at Oxford, to which he had got a scholarship, and he was the first in his family to go to university. Professor Townshend was elected a Fellow of the British Academy in 2008. As a historian, he has focused on Ireland and Israel-Palestine. He has said that all history is potentially contentious, but the level of contention depends on the degree of public engagement in the issues at stake. In both Ireland and Palestine-Israel, it's far more intense than anything in England or even Scotland would be capable of. So I think we could endorse that. His books on Middle Eastern matters include When God Made Hell and the British Invasion of Mesopotamia and the Creation of Iraq. He describes the reason his research took him in an Irish direction by saying, "My eventual research direction was determined above all by the British government's decision to reduce the 50-year closure of public records to 30. All of a sudden, a wide tranche of post-World War material was released. I went to assess the records in British post-war military action in the Middle East and in Ireland, and at that stage my knowledge of Irish history was strictly limited to Gladstone and the Irish question. But at that time the records on Ireland were in a much better shape than the Middle Eastern material. I read Dorothy McArdle's The Irish Republic, and I was hooked." He has said that his new book, The Republic, is a semi-direct tribute to that brilliant polemic. As we head towards 2016, Professor Townshend's book, Easter 1916, The Irish Rebellion, is gracing the shelves in our bookstores throughout the country. As a result of his original and extensive research, he gives us a most detailed description of that time and the participants. He introduced us to an incredible panoply of people and places and brings us street by street through the week's fighting. Indeed, when reading his story, it is as if one is walking along the streets of Dublin at that time in Dublin during the Rising. That gift and the hard work involved in original research is evident in his book, The Republic, The Fight for Irish Independence, of which there have now been 6 editions in the last 2 years. And indeed, our congratulations to Professor Townshend, who has just been awarded the 24th Christopher Ewart Biggs Memorial Prize for that book, The Republic. The objectives of the Ewart Biggs Memorial Prize are to recognise work that promotes and encourages peace and reconciliation in Ireland, a greater understanding between the people of Britain and Ireland, or closer cooperation between the partners of the European Union. In his work, in addition to his book, The Republic, Charles Townshend exemplifies the objectives of the Ewart Biggs Memorial Prize. Tonight, Mr. Justice Charlton will be another voice in the lecture that we are about to hear, but I would ask you to welcome Professor Townshend, who is going to speak to us on soldiers and law in the Irish Revolution.
Well, thank you, Chief Justice. I'm not sure if I can live up to all that, but thank you, and thanks to the committee for inviting me to contribute to this important series. The definitive revolutionary leader of all time, at least in my humble opinion, was a lawyer. He was Maximilien Robespierre, and for anyone who studied that fascinating roller coaster ride of rationality and emotion, the French Revolution, which was surely the definitive revolution, lawyers were key natural drivers of the revolutionary process. So when we contemplate the centenary of the Irish Revolution, it may be natural to ask, where are the lawyers here? Of course, Patrick Pearse was a barrister, a junior barrister, but apart from him, lawyers were conspicuously absent from the first rank of the revolutionary leadership. Some played important supporting roles: George Gavin Duffy, Michael Comyn, Lawrence Ginnell, even indeed Tim Healy, provided high-level support for separatists who fell foul of the British law, as did solicitors like Michael Noyk more quietly, Kevin O'Shiel, Kevin O'Higgins. Hugh Kennedy took more directly political roles, and so, of course, did some on the government side, such as Dennis Henry, and most notably perhaps William Wiley. But the leader, arguably the definer of the Irish Revolution, Pearse himself, did not take his stand on or use the law for political ends. Law school doesn't figure noticeably in the educational experience of the revolutionary generation, which has been so brilliantly explored in Roy Foster's recent book, Vivid Faces. Law doesn't even appear in his index, although neither, to be fair, does mathematics, notwithstanding the prominence of at least one maths teacher. David Foxton, the author of the most careful and comprehensive study of the part played by lawyers in the War of Independence, called Revolutionary Lawyers, has suggested, in spite of his own book's title, that the concept of the revolutionary lawyer is in many ways oxymoronic, because legal training equips people for reform from within rather than violent overthrow from without. And lawyers tend, of course, to have a vested interest in the legal system they have laboriously mastered. But in some situations, as say in 17th century England or 18th century France, where legalism could be deployed against arbitrary government, lawyers can indeed be agents of revolutionary change, albeit perhaps in the spirit of the dictionary definition of revolution, that is, returning around to a starting point. Might the same have been done in Ireland? There was certainly scope for nationalist lawyers to base a challenge to the legal regime in Ireland on the ordinary law. The history of the United Kingdom since 1801 had been a history of exceptional legislation, brought in to redress the perceived weakness of the ordinary law in the face of persistent resistance, sometimes armed resistance. Fundamental principles like habeas corpus had been suspended more often than seemed naturally to fit with the English idea of consensus government. The land war of the 1880s led to a distinctly un-English permanent statute, the so-called Crimes Act, actually the Criminal Law and Procedure Ireland Act 1887, which allowed the Lord Lieutenants to proclaim districts in which special courts of summary jurisdiction consisting of 2 resident magistrates would try public order offences. That very Irish figure, the resident magistrate, was himself a testimony to the awkward adjustment of English legal methods to Irish circumstances. Stipendiary magistrates, first introduced by Robert Peel in 1814, were extended across the whole country by the Constabulary Act of 1836. And the institution would in fact survive the mass dismissal of its incumbents in 1922 via a name change. And in fact, the Free State's new district justices were appointed under the 1836 Constabulary Act. It could have been maintained that the United Kingdom state in Ireland rested on law that was in effect special powers legislation, whose necessity was at least disputable. The Great War, whose centenary we are now remembering, brought this syndrome to a culminating point. The Defence of the Realm Act at the beginning of the war represented a dramatic lurch away from normal law.
Undoubtedly, the most dictatorial abridgment of English liberty.
As Clinton Rossiter put it. An enabling act spawning a vast mass of regulations creating offences triable by court-martial. It would stand for many critics as proof, if proof were needed, of the pernicious dangers of delegated legislation. The accidental charm of its acronym, DORA, may have helped to make it feel a little less alien, but even in Britain it was accepted only as a sacrifice needed to win the war. Where war fever was less overwhelming, as it was in Ireland, DORA's necessity was still less easily accepted. It was strong meat, and the vital adjustment made via the 1915 Amendment Act, which allowed civilians to opt for trial by civil courts, was necessary to keep British liberal opinion on side. The Irish government, which had depended on DORA to sidestep the problem of Ireland's famously recalcitrant juries in anti-recruitment cases, was dismayed by the Amendment Act and had to abandon a number of prosecutions. In Ireland, this amendment was the first thing to go when the 1916 rebellion broke out, and the country acquired an alternative official title as the place
where His Majesty has by proclamation suspended Section 1 of the Defence of the Realm Amendment Act 1915.
Yes, I think that's a nice sobriquet for Ireland. But suspension of the right to civil trial was only the start of things in April 1916. The government went on to proclaim martial law, even though it clearly did not need martial law as such, and martial law powers were, in the event, never used. All the trials of the 1916 rebels and alleged sympathizers took place under the Defence of the Realm Act. The fact that this was simply a declaration in terrorem did little to reduce the political risk of such a dramatic and almost certainly unjustifiable step. General Maxwell was described in another risky theatrical gesture as military governor of Ireland, and his regime attracted, alongside the praise it received from, say, the Irish Times, alarmingly fierce condemnation from the usually cautious leadership of the Catholic Church. Bishop O'Dwyer's celebrated denunciation of it as
one of the worst and blackest chapters in the history of the misgovernment of the country, characterized by fatuous and arbitrary abuse of power,
was a spectacular own goal for the authorities. O'Dwyer singled out 2 legal or illegal proceedings: the shooting in cold blood of the surrendered rebels and the deportation,
without a trial of any kind, of hundreds and even thousands of other poor fellows.
This might have been a slight caricature, but it was a recognizable one. Now, all legal proceedings take place in cold blood, or so at least one would hope. So this should be a good rather than a bad thing. Yet, the British failed to get the credit they might have been due for their decision not simply to put the rebels up against a wall, but instead to go through the process of bringing them to formal trial. And this was in part because of the way the trials were conducted. The proclamation of martial law at least created the possibility of using so-called drumhead courts-martial. That's an ill-defined concept because the drums themselves, of course, were long since gone, but one suggesting an abbreviation of procedure so dramatic that trial and execution might take place within 24 or 48-hour period. A very rapid acceleration of justice. And this seems to be what General Maxwell had in mind. And though it would hardly have been politically attractive, if he'd pressed ahead with it immediately, it seems unlikely that he would have been stopped. The crucial intervention was that of his Deputy Adjutant General, Joseph Byrne, who arrived in Dublin with Maxwell and reported that the Commander-in-Chief had set out with the intention of trying all prisoners by military courts held under martial law, but that he persuaded him that the Defence of the Realm regulations were adequate and, most crucially perhaps,
will not raise any difficulties afterwards.
He meant political difficulties, and he might have been right, but for the fact that most people failed to notice the difference and simply assumed that the courts were indeed being held under martial law. Maxwell had no formal legal advisor. Byrne himself was not a lawyer, and actually the most senior lawyer in Irish Command was a recently commissioned second lieutenant by the name of Alfred Bucknell, an Admiralty barrister who had no experience of criminal or court-martial work. It's been suggested by Sean Enright in his study of the 1916 trials that Maxwell's decision to conduct the trials by field general court-martial, the kind of summary courts routinely used by the army to deal with breaches of military law,
had simply not been foreseen.
By the man who sent Maxwell over to Ireland, the Prime Minister, Henry Asquith, himself a lawyer. It probably stemmed from Maxwell's belief that his required him to carry out the trials as quickly as possible. There was, as Enright insists, a big difference between the field general court-martial, a rudimentary form of trial by three officers, usually a colonel, a captain, and a lieutenant, whose normal purpose was not primarily to administer justice, but to maintain military discipline on active service. And on the other hand, general courts-martial, much more formal affairs which called for 5 judges, one of whom must be a qualified lawyer, that's a judge advocate, and which followed formal legal procedures. The decision to stick to DORA created its own difficulties, procedural if not political. The Act spoke of trials by court-martial, but thanks to the 1915 amendment, very few courts-martial had actually been held in Britain. The possible far outstripped the actual, as Clinton Rossiter noted. Maxwell was entering almost uncharted territory when he opted for trial by field general court-martial. As Enright says, officers with wartime court-martial experience will have been accustomed to assuming that the accused was guilty. A bigger problem, though, was that under DORA, capital sentences could only be imposed for actions intended to assist the enemy. This proved to be much more difficult to demonstrate than had been thought, if indeed it had been thought about at all. Even the apparently common sense assumption that the proclamation of the Irish Republic, with its very public gesture to
gallant allies abroad,
would suffice to convict its signatories, proved problematic. A printed name on a poster is quite different from an actual signature. The very first trial of Patrick Pearse on the 2nd of May could have collapsed if Pearse himself, who, as a lawyer, surely knew exactly what he was doing, had not obligingly added a postscript to his last letter to his mother, spelling out his reliance on German help. And he said, once he was convicted, he added at his court-martial,
"We have kept our word with her, and as far as I can see, she did her best to help us. She sent a ship with arms. Germany has not sent us gold."
But as we can see, in fact, Pearse admitted to relying on German help, but he never actually admitted helping Germany, so in a sense, technically under DORA, he was still not guilty. In prosecuting those who'd not signed the proclamation, proving a German connection was virtually impossible. Moreover, Republicans who wouldn't have denied the charge of levying war against the king, which I think they'd have regarded as quite a respectable thing, were able to plead not guilty to the charge of assisting the enemy. Maxwell's decision to exclude the public from the trials added another propaganda own goal, since they inevitably came to be described as secret tribunals. The decision itself was strictly illegal, since field general courts-martial, as well as general courts-martial, were public courts, even though in the circumstances of most courts-martial on active service, there was, of course, usually no public around. The exclusion in 1916 was justified on the grounds of public safety and the administration of justice, a formula whose relationship to the situation in Dublin was never explained. So, though nobody impugned the correctness of the officers who presided over most of the courts-martial, Brigadiers Blackadder and McConkie, there's one of them there, the proceedings they conducted were definitely flawed. The final weakness of the trial procedure lay in the quality of the evidence brought before them. Here again, Maxwell's haste brought problems, even though it could have been said to be justified by the need to act before military witnesses were removed from Ireland in the course of draft finding for the front, because the army had not even started to carry out identification parades or examine seized documents to assemble evidence until the day before the trials were due to begin. Vital evidence, such as the list made of the garrison which surrendered at Jacob's factory, for example, seemed to have disappeared. Virtually no evidence was secured through interrogation, and the process of deciding even who was to be tried was, as Enright rightly says, capricious. Asquith promised to publish the trial proceedings,
too definite to get out of,
as he grumbled, proved to be an uncharacteristically reckless one, which ran into a wall of military resistance. Even before he fell from power, the Army Council, that's the Army Council of the British Army, I hasten to add, was preparing to dig in its heels, and the Adjutant General pointed out for the Cabinet's benefit that there was no legal justification either under the Army Act or DORA for a court-martial to be held in camera. The evidence had been
far from conclusive.
In some cases, publication could
properly be deemed to be a complete admission that there was no justification for trial in camera.
Maxwell himself added that publication would be a
distinct breach of faith with those who took the decision
to exclude the public, as well as
a grave indiscretion.
That's the worst thing. Although the Judge Advocate General advised that the decision had been justified because holding the proceedings in public might have endangered the lives of the court and witnesses, he also opposed publication. Eventually, in March 1917, Asquith's successors announced that
in the present circumstances, to publish the reports would be to reopen memories of the rebellion, and that would do nothing but harm.
And the proceedings accordingly remained secret for over 80 years. So faced with a regime of dubious legality, unable to evoke a governing consensus, there was potentially a role for revolutionary lawyers to base opposition on legal principles. But the principles invoked would have been those of common law, i.e., quintessentially English principles. This drastically reduced, if it didn't actually remove, the political attraction of such a course. The existing legal system was
the standing monument of an alien government,
as William T. Cosgrave would later put it.
The body of laws and the system of judicature imposed on this nation were English, not even British in their seed, English in their growth, English in their vitality.
So insofar as the law was deployed in the service of revolution, it was through the lawyers who acted for prisoners who opted to enter pleas in the courts before which they were arraigned. And many did so, though the revolutionary line diverged from this one towards the rejection of state law. It was a gradual process, starting with the refusal to recognize the jurisdiction of the British courts, continuing via a general boycott of the legal system, accompanied by a violent assault on several of its component parts, and culminating in the construction of an alternative legal structure. So I just glance briefly at the sort of three phases of this process. The beginning is non-recognition. And in 1916, the rebels had no agreed policy of challenging the jurisdiction of the courts-martial that tried them, perhaps surprisingly. Non-recognition was first adopted as a strategy early in 1917, when the Brennan brothers, Austin, Patrick, and Michael, in military detention in Cork, told the solicitor who proposed to arrange their defense,
"We would take no part in proceedings."
Now, this policy remained inconsistent. Thomas Ashe, who was tried by court-martial in September 1917, refused to retain a legal counsel, but then went on to conduct his own defense. But it did gradually develop a greater consistency. A general policy emerged that arrested Irish volunteers should display
a dignified but defiant questioning of the authority of the police, etc.
And should notify their superiors of any elaboration of the attitude they would adopt beyond simple non-recognition of the court.
The platform offered by the court should be made as much use of as possible to pour ridicule and contempt upon the legal process.
But no explanations or alibis were to be offered. The police in West Galway associated this policy with a more general and rather alarming
tendency on the part of the people not to recognise British law in Ireland.
So this has some powerful revolutionary potential. Now, secondly, direct assault. Alongside non-recognition, it was logical to try to impede or paralyse the working of the Crown Courts. The offensive began with a boycott, which was, of course, a proper Sinn Féin method, but which, like most successful boycotts, was accompanied by what the great historian F.S.L. Lyons called a penumbra of violence, the physical force favoured by the Irish volunteers. Again, the process did not come together immediately. Late in 1917, the Tipperary Sinn Féin leader, Eamon O'Dwyer, called on people to ignore the law courts, but in case his audience thought that he was preaching a pure Sinn Féin doctrine of passive resistance, he made clear that while the great movement on foot to secure independence by passive resistance was
all very well in its way, but it must also have the support of rifles and machine guns.
I think he was optimistic there in thinking of machine guns. Now, intimidation was certainly present from 1917 onwards, maybe even earlier, but it only became systematic in 1919. It peaked in the early summer of 1920, when jurors routinely received notices advising them that obeying a summons to attend court would be
considered an act of treason against the Irish Republic.
In some places, armed pickets turned back those who tried to get to the courts. In Galway in July 1920, 13 out of 200 special jurors and 21 out of 250 common jurors attended, figures that could only be seen as disastrous for the legal system, despite the courage or perhaps foolhardiness of those 34 people. Finally, substitution. O'Dwyer's exhortation to boycott the system was accompanied by a promise that arbitration tribunals would be set up by Sinn Féin, the germ of what would in 1920 become an alternative court system, indeed an alternative law. The revolutionary potential of this idea would be hard to miss, yet its centrality to the revolutionary movement would come to be sidelined over the half-century after 1922. The Republican courts, swept away by the Free State government in July of 1922, almost disappeared from most histories of the Irish Revolution. They didn't get a full historical study until Mary Kotsanouris published her book Retreat from Revolution about 20 years ago. Her title suggested that the Republican court system had formed a key part of the revolutionary movement, but was abandoned in what could be seen, to use another French revolutionary analogy, as a Thermidorian counter-revolution. How true is this? I think the answer depends on the point you view it from. How revolutionary were the Republican courts? In the view of another historian, Heather Laird, the system was often only alternative to the extent that it allowed people to take their legal proceedings to an Irish as opposed to a British court. The Republican court structure directly mirrored the existing High Court, County Court, Petty Sessions structure. She cites Conor Maguire, who's a leading Republican court judge, his claim that,
except for the absence of judicial robes, the courts were carried on exactly as were our opposite numbers of the established British system.
Mary Kotsanouris suggested that there was nothing of a revolutionary court in the way the business was conducted or in the run of decisions. Now, if this means they didn't operate like the French or Russian revolutionary tribunals, that might only be to recognize that the Irish Revolution was less ideologically murderous, less dedicated to rooting out and destroying enemies of the revolution. Not necessarily a bad thing, perhaps. But a noticeable difference, to lawyers at least, was the virtual absence of barristers after June 1920. Very few of them defied the Bar Council's ruling that month that participation in a Sinn Féin court would be professional misconduct. But the Law Society proved to be more adaptable, and solicitors proved quite capable of filling the gap. The historian Arthur Mitchell has suggested that in the rough and ready brand of justice dispensed in the Republican courts, the absence of barristers was hardly noticed. To those who see greater revolutionary potential in the earlier manifestations of what Laird labels subversive law, the new courts had a deeper defect. For the most part, they adopted not only the organization, but also the ethos and value system of the legal institutions they displaced. And if this was true, how did it happen? One factor surely must be the inherent difficulty of conjuring up a complete legal order de novo. The folkish unwritten law was hardly enough in itself, even with the addition of the incomplete memory of the Gaelic law. On the other hand, one might say that Irish statute law had been distinctive even under the Union, and so to some extent was the whole Irish legal system, though that, of course, did not necessarily make it any more Irish in the Irish-Ireland sense. There's certainly no doubt that the implementation of the promise of alternative courts, as made by O'Dwyer, was spurred on by the need to preserve social order. The system had been launched at national level as early as August 1919, but little had been done to put it into effect. Kotsanouris noted the Dáil government's apparent reluctance to grasp the opportunity presented by the willingness of the people to abandon the regular courts and embrace an alternative access to justice. Art O'Connor more picturesquely spoke of the Dáil
shrinking from its duty as one shrinks from the fulfillment of an unexpected joy.
Austin Stack, the Dáil Minister for Home Affairs, was a bystander as the arbitration court movement mushroomed in the spring of 1920. It was the simultaneous upsurge of agrarian disturbance, which O'Connor frankly identified as the mad onrush of the revolution, that spurred the official response. Kevin O'Shiel was unembarrassed to offer the most traditional conservative, if not reactionary, take on the rural conflict. The people,
intoxicated with the wine which they drank to the dregs, confused license with liberty.
This, for the Dáil government, was anarchy, red or black, if you like, in tooth and claw. So lawyers such as Arthur Cleary, Conor Maguire, James Creed Meredith, Cahir Davitt came to play a central role in the establishment of an oppositional legal system, which perhaps unsurprisingly turned out to be rather conventional. In this, it surely mirrored the conservative nature of Irish society. rather than being imposed on it, and this, I think, amplified its capacity to accelerate the Republican project of establishing an alternative government and building a counter-state. There seemed to be real popular enthusiasm, not for arbitration courts, but for courts of justice with full powers. The Manchester Guardian, which had reported the spontaneous springing up of arbitration courts on the West Coast in mid-April, in early May called the rapidly multiplying tribunals
the natural result of the strong common will for national independence and national responsibility.
This line was almost certainly written, or at least directly inspired, by Desmond Fitzgerald, the Dáil's director of publicity. Republican propaganda tirelessly stressed the democratic implication of what it called people's courts. But it also subtly transposed the roles of party and people. A puzzled outsider, the American consul in Dublin, was told by Sinn Féin that they were
elated by the sympathy with which the decisions of their courts have been received by the people.
He reported to Washington in mid-June that if
the anomaly of the existence and claims of these courts be accepted, they appear to try to do rough justice between man and man.
And he added an acute historical rider.
Every successful revolution began by making the tenancy of the usurping government an impossible one, from which point revolutionary governments have proceeded to chain up and control the forces they have unloosed.
Now, the British government was slow to recognize the evolution of this process or to devise any kind of coherent response. When backbenchers at Westminster demanded to know early in June what was being done to stop the illegal and treasonable practices of the lawyers who were taking part in the Sinn Féin courts, the Attorney General could only reply that it was a matter for their professional bodies, the King's Inn and the Law Society. It took the landowner Lord Dunraven, rather than the government, to identify the fatal import of the new court system when it blossomed in the summer of 1920. When riding on the back of a concerted torching of abandoned police barracks and courthouses in the spring, the IRA intimidation turned the summer assizes into a humiliating fiasco.
An illegal government has become the de facto government, and we are in this curious dilemma that the civil administration of the country is carried on under a system the existence of which the de jure government does not and cannot acknowledge.
He drew the logical deduction that the cause of all the trouble was not dislike of law and order, but
a profound dissatisfaction with the origin of the law.
The arbitration courts movement, which had been adumbrated by Arthur Griffith, there he is, in December 1905, was a quintessentially Sinn Féin policy. It rested on public consensus and on non-violent civil disobedience. The spontaneous emergence of the system in 1920 looked like a dream, but the reality was that it couldn't work simply by tapping into some underlying popular sense of justice. Dissent appeared, rulings were denounced by losing parties, as indeed happened with the very first Dáil Land Court at Ballinrobe on the 17th of May. And to head off this resistance, or to quash it, the local volunteers were reluctantly recruited to enforce the rulings of the courts. Griffith's chagrin at this development is well attested, but it was inevitable once the courts were invoking and representing the authority of the Dáil. Politically, the Dáil could not afford to see its authority disputed. If it was to be recognized as a government,
it had to be prepared, like every other government, to use the coercion necessary to impose the collective will.
Local volunteers had already acted spontaneously as Republican police in some places, but now they had to provide an enforcement function on a regular basis. And not all of them were happy with this. Some saw it as a distraction from their proper business of fighting. Others did accept it as a necessary aspect of building the Republic. There was a fairly direct disagreement on this issue between the volunteers' two chiefs, Cathal Brewer, the Defence Minister, and Richard Mulcahy, the Chief of Staff of the Irish Volunteers, or the IRA as it was becoming. So the DORA courts were run by civilians but had no machinery to enforce their decisions apart from the Republic's army. There was certainly a considerable degree of popular participation in enforcement, but it was variable, and the credibility of the Republican legal system was significantly magnified by its military side. Whether in the process some of its soul might have been lost is a difficult question. Now, the flowering of the Republican courts was accompanied on the British side by a new surge of military courts, setting up a showdown between rival jurisdictions. The failure of the summer assizes forced the government to come to a decision about replacing the Defence of the Realm Act, which was a wartime measure that was due to end at the end of the war. After juggling for years with this concept of the end of the war and when it might be said to have happened, the government recognized that war emergency powers had at last reached the end of their shelf life. It settled for a new piece of special Irish legislation, yet another special Irish law, if you like, the Restoration of Order in Ireland Act, which restored many of the Defence of the Realm regulations, among other things giving the army wider powers of arrest and empowering courts-martial to try capital offences. Not without some soul-searching. When the Restoration of Order Act was being framed, the Cabinet saw that
it was a decision of the gravest moment to utilise machinery intended for time of war in peace, and considerable anxiety was expressed at thus handing over the whole administration of the law to soldiers.
Under the Act, the role of courts-martial was expanded, and the military courts of inquiry also replaced coroners' inquests. Over 800 courts-martial were held in the next 4 months, as against less than 100 in the preceding 6. And the race actually went on increasing, with 1,451 courts-martial in the first half of 1921. The conviction rate also significantly increased. Bowing to the sheer pressure of prisoner numbers, the authorities at last began to set up internment camps, because Irish internees had so far been housed in British prisons, creating a fertile source of contention. The very first at Ballykinler in County Down can be seen in this diverting clip, a Pathy newsreel, which, as you'll see, blithely refers to the camp as a concentration camp, a publicity own goal that wouldn't have happened any later in history. I think we can just about see the chaps. It is fairly remarkable that the British camp authorities had no problem with their prisoners practicing military drill and having classes on guerrilla warfare. That's the kind of regime it was. This actually is rather priceless. When I first saw that, I thought it was a parade of High Court judges. The autumn that followed the defence of the Restoration of Order Act was a torrid time. The military surge drove an ever-increasing number of volunteers to go on the run, and the consequent formation of full-time active service units, or flying columns, posed a new kind of military problem for the Crown forces. Eventually, the argument that the flying column operation at Kilmichael
partook of a more definitely military character than its predecessors
led the Cabinet to impose martial law at the end of the year. That recognition did not amount to a formal acceptance of a state of war, even though the Commander-in-Chief would be required to demonstrate that actual war was raging in Munster, to which martial law was effectively confined. He had to demonstrate this because, contrary to expectations, at least the expectations of the soldiers, cases were repeatedly appealed from the military courts to the civil courts in Dublin. At long last, drumhead courts-martial of the kind that so many assumed had been used in 1916 did make their appearance, but in a bare handful of cases. The great majority of military tribunals were still conducted on the basis of court-martial procedure, using a mixture of the existing rules governing field general courts-martial and the Army's circular memorandum on martial law. They were properly called military courts to avoid confusion with the statutory Defence of the Realm Act and Restoration of Order Act courts-martial. Less serious offences were dealt with by summary courses, the military equivalent of the two resident magistrate courts that had been established in 1920. The point of these tribunals, which had no status in law, merely giving effect to the will of the general commanding under martial law, was the pruning and acceleration of the legal process to the point at which the whole process might, as I said, I think earlier, take 24, 36, 48 hours. They didn't have to follow any formal legal procedures, but in fact they did, even requiring the lawyers who occasionally attended them to wear robes and wigs. They followed normal rules of evidence for the most part, though they changed a bit of it as it pleased them. Even the military courts didn't perhaps fully live up to the political caricature of them. Some of their proceedings could certainly not be called cursory. In the case of Michael Fitzgerald and others, the case lasted 5 days, 36 witnesses were called. The record of proceedings ran to 104 pages, and it's by no means the longest of such records. The very first court-martial to condemn a man to death, this is Cornelius Murphy, for improper possession of arms and ammunition, recommended mercy on the ground that Murphy was
a man of low education.
But the military governor of the martial law area, General Strickland, wanted the sentence carried out. The Commander-in-Chief was compelled, under protest, to refer the case to the Judge Advocate General, Sir Felix Castle, who I think we can see here, who was claiming, as Macready complained, to be
the sole law advisor in all cases where death sentences are passed.
Castle advised that
the officers of the court had the advantage of seeing the accused and judging by personal observation whether he was a person of normal mental capacity.
He suggested that
the recommendation of the court should carry great weight, more particularly as it is attached to the first death sentence for an offence against martial law under the proclamation.
He clearly saw this as a significant point, perhaps a political rather than a legal one, but he didn't really spell out its significance. He went on to give apparently equal weight to the military governor's strongly expressed view that the sentence should be carried out, telling Macready that he must decide whether execution was
essential for the restoration of order in the district.
Now, Castle's opinion has been seen by Sean Murphy as a veiled recommendation to avoid execution, but if so, it was, as he must have known, too veiled to prevail. The imposition of martial law enlarged the scope for legal resistance. Martial law was a contested concept, not just at the political level, but also in law. Politically, it was odious, and it had not been used in the United Kingdom for over a century. Its legal basis, whether in common law or royal prerogative, remained unresolved after centuries of debate. No lawyers were involved in the Cornelius Murphy case, which did move from arrest to execution in a month. But after that, lawyers were increasingly active in applying for writs of habeas corpus, as well as some less obvious writs, prohibition and certiorari, on behalf of Republican prisoners in courts which continue to sit outside the martial law area, specifically here in Dublin in the Four Courts. So began a process which challenged the jurisdiction of the military courts and ultimately the validity of martial law itself. Now, not all Republicans approved of this. Mulcahy himself was
not at all convinced that the proper attitude in all cases for Republicans would not be to refuse to admit the enemy's right to try them.
He particularly objected to the waste of Republican funds on legal fees in cases of
men taken in open warfare, where 99 times out of 100, nothing will be gained by putting up a defence.
But he had to accept that
the balance of opinion is not in favour of an order prohibiting men from defending themselves where the extreme penalty is involved.
And the majority of those tried did have professional legal representation. All of those on capital charges entered not guilty pleas. In the Michael Fitzgerald case I mentioned earlier, for instance, the 14 accused were represented by 4 barristers. Appeals were lodged against every capital sentence imposed by a military court. These legal challenges were intensely irksome to the Commander-in-Chief, who believed they seriously undermined the impact of martial law, not least by creating the kind of delay familiar to lawyers but anathema to soldiers. Even so, they all failed until the very last. The High Court might grumble. In the case of Guard and others, Justice Dodd snorted that
if we are here to merely register the word of a soldier that a state of war exists, I, for one, protest.
While Chief Justice Maloney rejected the
somewhat startling argument that it was not competent for this court to decide whether a state of war exists or not.
But in the end, it always endorsed the Commander-in-Chief's affidavit and rejected testimony that Cork, for instance, was a perfectly peaceful place. The dramatic increase in police and military casualties in 1921 seems to have been decisive in accepting the affidavit, as was the open claim of Republican propaganda that
in the South, the guerrilla offensive has been carried on for so long and so vigorously that the enemy can only rely on a big military concentration.
And once it accepted that a state of war existed, the High Court could not interfere with military courts. So that was fine for the military authorities up until May, when the Master of the Rolls accepted an argument which had been brusquely thrown out as having no foundation in law in Guard's case, that by passing the Restoration of Order Act, the Crown had surrendered any right to use its common law powers to proclaim martial law. Now, this deadly piece of legal ordinance was fired not by one of the Republican lawyers, but by the former Attorney General and Home Secretary, Sir John Simon. At the beginning of February, Simon commented in a London press interview on the case of Cornelius Murphy. While acknowledging that Murphy's offence, the possession of a loaded revolver, might be
breach of the law,
he posed the question,
since when has it been a capital offence?
The offence had been created by the army under martial law, and Simon argued that it had no power to do so. After passing the Restoration of Order Act, the government had consigned its common law emergency powers, in effect, to the dustbin of history. This novel contention provided the opportunity for the most serious challenge to the martial law regime, which in turn raised the political cost to Britain of another round of repression, the sort that would have been needed if the 1921 treaty negotiations had failed. So, in conclusion, if lawyers were not, for the most part, in the front rank of revolutionary leadership, they were certainly instrumental in making possible a sustained challenge to the established order. The soldiers, given a task for which they were not qualified, had done their bit to undermine it. Legitimacy is a sometimes mysterious and fragile quality. It would be hard, if not impossible, to quantify the United Kingdom state's legitimacy in Ireland at the outbreak of war, or to measure the scale of the task faced by the Republican counter-state in levering that mantle from the incumbent regime onto itself. For many at the time and since, the Doyle government was a sham, a pretense, a propaganda ploy, albeit a very successful one. But I think elements of it establish enough credibility to create the basis of legitimacy. And the court system was arguably the most significant. The clash of rival jurisdictions, which, as Kevin O'Higgins put it, had
battered out of recognition the wheels of administration,
must, I think, be ranked alongside the more spectacular clash of armed forces as pressures forcing a compromise peace. Thank you.